Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book which has come to us from Oxford University Press. It's this book over here, Proprietary Rights and Insolvency. It's now in a second edition and it's been written by Richard Calnan. It's a first-class book, an important book. The new edition is in 2016 and the first edition appeared in March 2010. Now, Elizabeth and I talked about this book in some detail, and for our book review we've given our review title the following: Get Hooked on Constructive Trusts. The new second edition of Proprietary Rights and Insolvency is out now. Now, I've always found the constructive trusts a fascinating subject ever since student days, and I'm sure many others have as well. This book actually will help you immensely. Let's have a look at it first of all. It's a hardback from OUP. There it is, front cover there. Then there's the spine, which you can see there. There's nothing on the back of any merit. There's the index. Now the index is used, it's 400 odd pages long, under 500. The index has got paragraph numbering, so you should see things reasonably easily. It's quite a detailed index, which I think is very helpful to find things at the front of it. Then you can see from the actual, this is obtaining a proprietary interest in an unconnected asset. This is part J, principles of the book. You can see its paragraph numbering there, which you can see deals with remedies right at the end. There are, of course, lots of footnotes to give you the detail for things like case law references and so on. If we go to the front of the book, you can see again there's the front page. Second edition, as I say, from Richard Calnan. Then there's a nice dedication, which I should just show you, from the author. And as I've indicated, there's a preface to the second edition, and it's well worth reading because Richard then sets out in this second edition what he's changed and what's happening at the moment on equitable proprietary interests. He's dated it December 2015, and the law is stated as around that time, December 2015. Then you've got a preface to the original edition, where he was talking about a whole range of changes that had taken place, and that was written 2009, beginning of 2010. The book appeared a few months later. There's the contents section, quite detailed, the various parts. There are 5 parts in total to the book, and it's got 9 chapters. They are sort of then, within the 9 chapters, they're then given sub-numbers, in fact sub-lettering rather than numbering. Then there's a detailed contents section running all the way through. After that, you've got the table of cases coming by different jurisdictions, starting with Australia and running all the way through. Then you've got lists of statutes and lists of statutory instruments, and you've then got the various parts. With a little sub-index at the front, we start off straight away with the pari passu sharing principle right at the beginning. And as I say, you have a nice index. Then you have the actual lettering for the parts, and then you do have the actual paragraph numbering. So you should be able to find things pretty quickly. And there's a lot of reference to case law throughout. Very helpful indeed. I found this book very useful. It's very much part of the style of Oxford University Press publications, and this is what we actually say about the book. It's a new second edition of Richard Calnan's highly regarded title, Proprietary Rights and Insolvency, and it has had a long gestation, but all the better for commercial and chancery lawyers. Insolvency practitioners in particular, I think, will find this a very great assistance, because it's looking very much at that particular equitable jurisdiction. Now, the first edition, as I've said, came out in 2009, and Calnan said it was a book which he'd wanted to write for 30 years, inspired by his early enthusiasm for constructive trusts. And I think a lot of us would have had an early enthusiasm, because the constructive trust, I always thought, was a wonderful device. You could construct a trust from all the things that had happened. It was a wonderful way of being creative, if I can put it that way. So it was rather interesting to see he had the same basic momentum, if you like, as I think many of us as students did. His mentor was Tony Oakley, who warned that there are topics of conversation more popular in public houses than the finer points of the equitable doctrine of the constructive trust. But by then, says Calnan, I was hooked. And I don't blame him, because it's an interesting area of law. And there's a lot of academic interest, certainly at the two big universities, Oxford and Cambridge, concerning how far certain judges were allowed to go with the operation of the constructive trust. And I'm not going to mention any judicial names at this point. Fast forward then to the recently published new edition from OUP, and you might well find yourself hooked on this book too, especially if you agree with the author that the availability of equitable proprietary interest is an important factor in the success of the law in meeting the requirements of commercial life. I think that's an important observation. Crucial in financial transactions, the author adds, is the ability to create security over practically any present or future asset. And again, I think that's an important observation. Replete with fascinating case material throughout, including important recent cases cited in most of the chapters, this new edition contains much new material which reflect recent developments, for example in insolvency law, that have emerged since the first edition was published. There's copious reference to the main cases in what is especially, of course, helpful about this book is that the principles of property law, which is actually the main focus, apply to the various types of proprietary interest, are very well illustrated and elaborated upon throughout. Thus is the structure of the law revealed, and I think he does a very good job, the author, in producing that information. Calnan, nevertheless, views with some alarm the relative lack of proper consideration being given to the interests of third parties, which he identifies as the defining characteristic of property law. This, he says, manifests itself in 3 decisions of the Supreme Court and the Judicial Committee of the Privy Council concerning, respectively, fiduciaries, equitable tracing, and issues pertaining to family homes. We are, of course, summarising here, and the family, the matrimonial home, the family home is, of course, a very important area for this jurisdiction. That said, busy practitioners will appreciate the logical organisation of the book into 5 parts. The first is the introduction, which covers the principles of pari passu, which is sharing in equal steps, in other words. Retaining and recovering a proprietary interest is the focus of part 2, and then part 3 goes on to deal with express agreements and implied or presumed agreements. Obtaining a proprietary interest in a substitute asset by operation of law is covered by part 4, which contains interesting chapters both on tracing in law and in equity, both of which I think would be very interesting both to the student as well as to the chancery practitioner. Part 5 elaborates on obtaining a proprietary interest in an unconnected asset by operation of law. What is striking, I think, about this book is its insistence on clear and detailed explanation of technicalities, sometimes illustrated by simple diagrams, and they do help. Paragraphs are numbered throughout, which I've indicated, with each chapter prefaced by a summary of its contents. There is an index of almost 20 pages, and, as you would expect, detailed tables of cases, statutes and statutory instruments. Definitely this is an authoritative, accessible and up-to-date work of reference which should find its way into the possession of all serious commercial and chancery practitioners. And the publication date is cited as at 2016, although obviously there's a bit of an overlap from the time of the introduction and the preface to the actual date of publication. There's the book again, nice green cover, hardback. You can see the spine there, just opening it in the middle. You can see this is dealing with family homes. We're looking here at recent judgments. Again, important areas of law are looked at. and the footnotes of course give you a lot of additional information should you need to do further research. Grant and Edwards, which is probably a case most of you will know, is well featured there. An important case which I remember certainly from my student days, and he spends quite a lot of time looking at that. They call it the family home rather than the matrimonial home today, bearing in mind these in Grant and Edwards they lived together but were not married. And you've got the requirements of tracing, equitable tracing. So you've got a huge amount of interesting information, and I certainly think it's a book that someone who's looking to achieve a high grade for certainly their law undergraduate exams, it's a book they should read, because by reference to something like this you're going to get the extra marks for your first. Thank you anyway to Richard Calnan for the new edition, and to OUP for the excellent work, and everybody involved in producing another great book for us. Thank you. Bye-bye.